We are on the record in the matter of Peyton Lewis, file number 19360.
All right, we're back for our second day on record in this case for the preliminary hearing. I have had the pleasure of a sidebar to understand some developments, and I'll let the attorneys address that after appearances.
Lee Heiss, lawyer guardian ad litem.
Ms. Saja Thomas, counsel for the department. Ms. Harvey.
Sarah Harvey, DHHS.
Michael McFarland, representing mother. Please introduce yourself.
Sarah Lewis, mother.
Michael Brooks, I represent the father, Mr. Lewis. Sir, would you identify yourself?
Justin Lewis, father.
Thank you. Comments about our sidebar, Ms. Thomas?
Thank you, Honor. As the court is aware, we did adjourn this a couple of days to look into whether we could get a safety plan in place for this family. Seems that the family was able to do that. And we were also going to look into whether there was maybe like a significant placement we could explore for the minor. That was explored, and it was not appropriate, I guess. So this person was not willing to provide continuous care for the minor. And so with that, our plan today is to continue to ask for the relief requested in the original petition.
Which is in-home jurisdiction with the removal of the older child, well, the older person.
That is correct, Your Honor.
Okay. Comments about the sidebar, Mr. Brooks?
Well, I'm the attorney for Mr. Lewis, and while I recognize there are real dangers to this decision or this placement, he is confident that he and his wife can meet the challenge and keep their daughter safe. So that's what I'm advocating.
Mr. McFarland?
Your Honor, I think we also discussed it, or at least I'll confirm again, but I expressed to the court that the 19-year-old is already out of the house, and he is already out of the house. So let the court know that my client, and father, is going to do the same. We're going to be pleading no contest because of the various sexual allegations, perhaps, and inability to properly supervise the situation, Your Honor, which could result in criminality.
My client's pleading no contest as well.
My client doesn't want to have the complaint read again, and she's been advised of arrest.
Well, all right. Deputy Ames, would you swear in Mr. Dustin Lewis and Sarah Lewis, please?
Remain seated, but please raise your right hands. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. All right. Ms. Lewis, do you have a copy of the petition?
Yes.
Mr. Lewis, do you have a copy?
You have to say yes or no, sir.
Yes, sorry.
That's okay. Thank you.
Sorry.
All right, very good. Well, as you know, you have the right to an attorney. You'll have an attorney provided for you at each hearing unless you decide to hire your own. And that's why Mr. Brooks and Mr. McFarland are here. I understand that you wish to waive your right to have the petition read, Ms. Lewis. Is that right?
Yes.
Mr. Lewis?
That's fine, Your Honor.
Okay, very good. Well, today I have to decide whether or not the petition should be authorized. And as I understand it, both of you wish to enter a no contest plea, which would mean that you would consent to the jurisdiction of the court for purposes of services on an in-home basis. Is that right, Ms. Lewis?
Yes.
Mr. Lewis?
Yes.
Well, the other thing that happens during a prelim is the right to admit or deny the allegations, the right to seek placement, which will automatically really be addressed by the entrance of the plea and the proposed arrangement. Do you know of any other guardianship or custody or even juvenile delinquency proceedings that would concern your daughter?
No, not that I know of right now.
Not at this point.
Okay. Do either of you have any reason to believe you have Native American heritage in your family?
No.
No, Your Honor.
All right.
At least nothing proven.
All right. Okay. All right, well, as it relates to the no contest plea then, would you agree, Ms. Thomas, to that request?
Yes, Your Honor.
Ms. Heiss, what are your
Yes.
thoughts?
Yes, I believe there is potential criminal liability, and it isn't necessary for us to have a guilty plea to get this family into services. I think no contest is appropriate.
Thank you. All right, Mr. and Ms. Lewis, a no contest plea essentially means that you don't have to affirmatively tell me that you are responsible for any of these things, but I will basically take each and every allegation of the petition and assume that it's true. Do you understand that?
Yes.
Clarification, Your Honor. My client has advised me that on her husband's side of the family, they've been informed that they have Cherokee blood from Southeast United States. They haven't verified that. I think we still probably have to explore that if it's been brought to my attention.
Okay, Ms. Harvey, I know that this is not the first time we've interacted with this family, so if you could check and see if that heritage search has been done, or of course, resubmit it as necessary.
Narrow it down
Yeah.
as to the track.
Cherokee.
Yeah, I'll check and see, just the Cherokee, if we've done it before, I'll check.
Thank you. All right, very good. Okay, Mr. Lewis, did you hear my comment about the no contest plea?
Yes, Your Honor.
All right. Well, if I accept your plea, Mr. and Ms. Lewis, you are giving up your right to a trial by judge or trial by jury, the right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, the right to have witnesses against you appear and testify under oath, the right to cross-examine those witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You understand you'll be giving up or waiving the rights I've just indicated to you if you enter your no contest plea, Ms. Lewis.
Yes.
Mr. Lewis.
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home and order counseling or other programs for you and your child, such as drug and alcohol treatment, assessments, or parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Lewis?
Yes.
Mr. Lewis?
Yeah.
Do you have any questions about any of the information that we've gone over so far, Ms. Lewis?
No.
Mr. Lewis?
No, Your Honor.
All right, is anyone making you enter a no contest plea, Ms. Lewis?
No.
Mr. Lewis?
No.
Has anyone threatened you in order to get you to enter a no contest plea?
No.
No.
Outside the terms of the plea agreement, which I think are essentially just the fact that it's gonna be no contest, has anyone promised you anything in order to get you to enter a no contest plea?
No.
No.
Would you, are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this morning?
No.
Would you say your decision to enter a no contest plea is one you've made of your own free will?
Yes.
Yeah. Yeah. What she said.
Okay. As it relates to the factual basis of the plea, Ms. Thomas?
Thank you, Your Honor. If Ms. Harvey can be sworn in to provide that.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Full name, one more time.
Sarah Harvey.
Ms. Thomas.
Thank you. Ms. Harvey, today the parents would like to enter a no contest plea. And in part of that, there needs to be a factual basis for their plea. How are you involved in this matter?
I'm the CPS investigator.
And do you believe that as the investigator, you have sufficient knowledge as to the facts that are, or the allegations that are contained in the petition?
Yes.
And you in fact drafted the petition, correct?
Correct.
What, during your investigation, what were the concerns that led you to file this petition?
The original allegation came in with allegations of sexual exploitation by an adult sibling of PL. There were also concerns about marijuana usage in the home at that time.
And what investigatory process did you use or undertake to ascertain whether those were valid concerns?
Initially, an on-call worker did interviews alongside an officer from Madison Township. At that time, the adult sibling indicated that he had been in a bathroom in a hotel where PL and LS were staying for the day. They would go to work with PL's mom. Then they would go swimming at the hotel and kind of hang out in the hotel room. He indicated that he had been in the bathroom making videos and had left his phone in the bathroom recording. PL and LS then entered the bathroom without knowledge that the phone was recording, and undressed and took a shower together. That was the initial interview. We did do a CAC then as a follow-up. At that CAC, both LS and PL indicated that this was not the first time that they had been recorded by the adult sibling. That a year ago, they had found a phone put in a windowsill, kind of half behind a curtain, that was recording them inside PL's bedroom. They also, PL indicated that at one point when they were younger, the same adult sibling, now adult sibling, had attempted to touch her breast. And she had each time taken this information to her parents, and she felt that her parents did not have a response to the situation. No safety barriers were put in place at that time. We also did look into the allegation of marijuana in the home. While the parents have use of marijuana, it wasn't an indication that they were providing marijuana to PL at that time.
Thank you. And during your investigation, was there any indication that the parents believed PL and what her brother was doing?
We did have a family team meeting where both Mr. and Mrs. Lewis expressed some concerns that PL may not have been truthful in her response. We did tell them what the adult sibling had told the officer. And they were also, at that time, the adult sibling made some threats that could be heard by workers because we were on a Zoom FaceTime. He made some threats to her, which heightened the concern for PL's safety with the adult sibling in the home.
Were the parents immediately agreeable to removing the adult sibling from the home?
No, they reported that they did not have a place for him to go. There was no appropriate family member where he could stay, and there was also no appropriate family member or friend for PL to go to.
And
They reported they
sorry.
reported that the safety plan that they had in place was that the adult sibling no longer had a phone because the police had that phone. So they thought that she would be safe.
And has PL been removed from the home in the past due to concerns of improper supervision or failure to protect against another, I guess, individual?
Yes, in 2019. Yeah, in 2019, she was removed from her home for improper supervision, which resulted in sexual abuse by a third party.
Thank you. Your Honor, for purposes of factual basis, I have no further questions of Ms. Harvey.
Gentlemen?
Just one. What's the current status? Is there a current active investigation by the Madison Township Police?
Madison Township Police had to turn over the investigation into Maumee, Ohio Police because it was a jurisdictional issue. This did take place in Ohio. As far as I know, at that point, they're still investigating.
Did you keep us up to date on that?
Yes.
Nothing further.
Any questions, Mr. Brooks?
No, Your Honor.
Ms. Heiss?
Ms. Harvey, The agency's recommending at this point placement of the older boy out of the house, leaving the child in in-home jurisdiction. Is that correct?
Correct.
So the ongoing service person will put in a safety plan. I assume that will address you know, we don't want contact between these siblings that's unhealthy, but we don't want no contact if it can be supervised. I don't know the nature of their relationship, but we'll address that, correct?
Yes,
Can we also safety plan no unrelated adults in the home for the time being, just to protect? It seems to be a issue from the last case.
yes, we can put that in the safety plan.
Can we be sure that the parents are compliant with any medication as prescribed? I don't know yet, but will we be checking on that?
Yes, Peyton will need numerous services started and put in place, and all of that will be monitored by the ongoing worker.
Okay, and the last thing is, are you willing, in 2022, this child was on juvenile probation or for some vandalism type thing. Would you be willing to partner and maybe have the probation officer join an FTM so we can hear what services they provided and what was successful and learn from their case?
Yes, yep, we can do
Okay.
that.
Thank you. I have nothing further.
All right. Are the attorneys satisfied with the factual basis of the plea and the advice of rights?
I am.
I am, but I do have a follow-up question.
Okay, one moment. Ms. Thomas, Ms. Heiss,
Yes.
Your Honor.
go ahead with your question.
My understanding is the 16-year-old minor, she's now 16, correct?
Correct,
She does have a boyfriend.
correct.
She may wish to have contact with him, so if we have no adult in the house.
Correct. We will put that in, we'll address it in the safety plan.
do have,
Hang on. Okay, so you're not saying that she can't have contact with her boyfriend, but just in a supervised setting?
Yes, correct.
Thank you.
Thank you for your testimony. May I return to your seat? All right, the court is satisfied that the plea is knowingly, understandably, and voluntarily made. I further find the record supports one or more of the statutory grounds alleged in the petition are true. Ms. Harvey has detailed the issues in the home as it relates to the factual basis of the plea that also constitute the actions that do violate MCL 712A.2b, which indicates in this particular case under sections 1 and 2, there has been a violation as it relates to the parents failing to protect, and the language of the statute really specifically indicates the child's parents, when able to do so, neglects or refuses to provide care necessary for the child's health or morals, who is subject to a risk of harm to her mental well-being, which has been clearly established by the testimony of Ms. Harvey. Secondly, that the child's home or environment with her parents by reason of that neglect or depravity on the parent's part is an unfit place for the juvenile to live in. I also find that that's been met as a result of the victimization of this child in the home on a sexual basis and the failure of the parents to intervene and protect her from the same. Above the order of the court that Mason Lewis is ordered out of the home, in addition to the court's jurisdiction over both parents and the child. We'll count on the department to continue to look for resources for the family and for the 16-year-old and begin all of the referrals for the family, whether that's CMH or ACPC. I'm sure that this child is going to need some support around her mental, physical health, emotional health. So we'll look for all updates on all of that at our initial disposition, which is our next court hearing. Between now and when we come back, the department will meet with you, Mr. and Ms. Lewis, to put together a plan to set some goals and a course of action. And this court will then monitor on a semi-regular basis, at least every 3 months. And hopefully you'll reach those goals and you won't have to have the interference of the court in the future. For our next court date, that's within 28 days. And I have some time available at 11 a.m. on Friday the 23rd, if everyone's available.
February 23rd, Your Honor?
Yes, at 11 a.m.
Judge, I have that we had
Have you
a
already filled-
review. Yeah,
Well, I know we just did the. Okay, All right, well, maybe I'll look this up.
But it looked in my calendar, I also have that set for 9, so I'm not sure what happened
Which
there.
one?
Miller,
Which-
there's a 9 and 11 in my calendar. I don't know, Lee, what you
I
have.
just have 9.
Okay. My
I just
calendar's
have
like
9, but
I'll tell you.
We're figuring.
So
it out.
11. I think 11 is clear. If it doesn't work, then we'll find some time another day, but I think 11 AM on Friday the 23rd does appear to be open at this point. I have been known to double book occasionally, but if we figure out that that's a problem, we'll let you know as soon as possible. So we'll be back for disposition February 23rd at 11 AM. The child is in the home that is the safest and least restrictive at this time, allowing that her older brother will not be residing there, at least for the time being. And we'll be working, the department will be working with the family to continue to work on safety and boundaries in the home. Understanding too, the court is still looking for opportunities for the child as well, to potentially stay in another residence. All right, any questions? All right, I'll have the order ready for you in just a few